If cops claim emergency, can they trespass into your home? For nearly half a century, cops and courts have used two words, exigent circumstances, as a basis to do certain things and act in certain ways that would normally be unconstitutional. In this video, I'm going to break down what exigent circumstances really means, and we're going to cover the three emergencies that cops and courts have used in order to justify entering into your home without a warrant. And if you wait around till the end of the video, I'll talk about exactly what you can do and what cops are limited to doing if they use this excuse in order to get into your home. Legally, the only way a cop can ever get into your home is either by number one, your consent, number two, a valid search or arrest warrant, or number three, the dreaded exigent circumstances. Let's start off with the easy ones. We already know there is zero reason you should ever give police to enter into your home with your consent to search your home. Think about it. If you let them into your home to do a search, not only does that cure all, anything they find can and will be used against you, but now you actually give them a license to tear up your entire house. In fact, if the cops don't have a valid search warrant or arrest warrant, and they don't have exigent circumstances, you shouldn't even open your door. That's right, you can actually ignore a police officer at your front door unless they let you know they have a valid search warrant. But what about exigent circumstances? Can cops just barrel into your home and trespass into your front living room through your front door in the name of an emergency? There are two Supreme Court cases we want to look at here. Number one is Mincy versus Arizona from 1978. And then more recently in 2011, there was Kentucky versus King. And this is what the Supreme Court said. They said that sometimes there are, quote, the exigencies of the situation make the needs of law enforcement so compelled that a warrantless search is objectively reasonable under the Fourth Amendment. In reality, the Supreme Court set up this exception to a warrant because they say that sometimes cops just don't have time to get a warrant. But although this may sometimes be true, many cops will jump the gun on this exception to a warrant in order to enter your home, and they will claim an emergency that really doesn't exist as a basis to violate your constitutional rights. Let's be clear. When I find out that a police officer has entered into someone's home without a search warrant, I begin to really dig deep into the file to find exactly how this police officer has violated this homeowner's constitutional rights. Why? Because some officers have a tendency to write conclusions rather than facts in their police reports. Police officers must clearly articulate facts, identifying specifically why this was an emergency situation, creating exigent circumstances to enter into your home without a warrant. Otherwise, it is likely an illegal entry into your home because a warrant would have been required. Let's take a look at the three most common emergencies courts have recognized allowing cops to act without a warrant. Number one, an emergency scene requiring emergency aid. Let's say police officers receive a dispatch call about possible shots fired inside of a home. So the cops show up to the scene and then they break down the front door in the name of providing emergency aid to a possibly injured person inside the home. Is that what we mean by an emergency scene requiring emergency aid? Not so fast. I see cops mess this one up all the time. Police many times misunderstand this exception. I see cops mess this up all the time. In fact, police officers tend to get confused between the difference of the community caretaking doctrine and the emergency scene exception to a warrant. Many officers think they can barge right into someone's home in the name of the community caretaking doctrine. And under that doctrine, it essentially says that police officers do not need a warrant if they believe someone is in dire need of the officer's assistance and the officer doesn't have time to obtain a warrant. The problem? Number one, Canigula versus Strom taught us, a 2021 Supreme Court case, that the community caretaking function does not apply to your home. And the second problem is the community caretaking function is not the same thing as the emergency scene exception to a warrant. This emergency scene exception was established by Brigham City versus Stewart, and it did a very good job of explaining the specific circumstances where a police officer can enter your home without a warrant in the name of an emergency. The case established that the police must be entering the home for an immediate injury. So we're talking about a medical emergency or an immediate injury that requires immediate need. They cannot be entering into the home for any other investigative purpose. In other words, it can't be a pretext. They can't claim, oh, I thought I heard something going on in there, so I just barged into your home. Now let me look around and see what you're doing. It must be specifically immediate to a known injury or medical emergency. Here's what is key. In order for the police to be able to enter into your home without a warrant, and if they're trying to claim the emergency scene exception, they are going to have to articulate facts in their police report that are well developed, showing that there was an emergency scene immediately happening inside of your home. Otherwise, the cops must have a warrant in order to enter into your home. And I see this happen. Sometimes an officer gets there, they hear that there was a dispatch, someone slams the door in their face, they don't like it, and now they claim there's an emergency scene going on inside. So when I say that you need to be looking for specific facts that an officer put in their police report, objectively establishing an emergency scene, we need to be looking for things like blood or screaming or something specific that makes it clear that there is an active emergency taking place inside the home. Otherwise, the cops must have a warrant. Cops merely coming out to some domestic argument call is not going to cut it, and it will not give them an exception to needing a warrant in order to enter into the home. If the officer enters into your home without a valid warrant and he's not able to articulate an emergency scene here, now what's going to happen is any evidence that is seized will be thrown out in court, and the officer could be potentially subjected to a civil lawsuit. Finally, under this exception, once the emergency is over, the officer must leave immediately. Cops can't just hang out and start looking around and cooking up an investigation. Emergency number 2, hot pursuit. What if an armed robbery suspect jumps your privacy fence and goes and hides in your shed in your backyard? Can cops legally break down your fence, search through your backyard, and if necessary, break down your shed in order to get to this robber? Yes, they can. But wait, don't cops have to have a valid search warrant in order to enter into my backyard with a privacy fence and conduct a search? Normally, yes, they would. But in this situation, the Supreme Court has said that if a fleeing felon, certainly a felon, has on foot entered into your backyard, and now the cops would potentially lose out on catching this suspect, if they had to go get a warrant, they can actually go into your backyard and potentially damage your property, and they don't need a warrant in order to do so. Now, what is really required, though, for this exception to kick in for cops? And this is really key. Cops must already have probable cause to arrest the person they're chasing after. In order for cops to use hot pursuit as an excuse to enter your property without a warrant, the cops must be able to show that the hot pursuit started in public and the crime was in public and then extended onto your private property. The probable cause to arrest this person that's on the run must also be for a felony, not a misdemeanor. Now, what if the fleeing person was involved in a misdemeanor instead of a felony? That's a completely different situation. Cops can't just start running after someone who's committed a minor traffic violation and use that as an excuse to actually invade your privacy by knocking down your privacy fence and doing a search through your backyard. In fact, in Lang versus California, the Supreme Court addressed exactly this issue. Lang was driving down the road, honking his horn and listening to very loud music. Cops then began tailing him and decided to pull him over. Cops then claimed they had probable cause to arrest him for failing to comply with a police signal, which was a misdemeanor. Lang then pulls up to his garage and flees into the garage and into the home, believing that they're not going to come after him. The key issue here is that the Supreme Court ruled that hot pursuit of a misdemeanor suspect does not necessarily create exigent circumstances or an emergency that allows cops to enter onto any private property without a valid warrant. In fact, the Supreme Court said that cops can only violate your home's privacy by chasing a misdemeanor suspect into your home or onto your property if, under the totality of the circumstances, it creates a true emergency. So, from a big picture perspective, does allowing cops to chase someone into your home without a warrant make a whole lot of sense for a victimless misdemeanor crime? The Supreme Court said no. So, what are the requirements for hot pursuit? Number 1, cops must have probable cause to arrest the fleeing person. Number 2, hot pursuit started in a public place and extended into your home, or the cops saw the person in a public place and they fled into your home. And then number 3, it must be for a felony or, under the totality of the circumstances, a true emergency. Finally, emergency number 3, what if evidence is being destroyed? This is the infamous Goodfellas movie, where Ray Liotta's wife is flushing cocaine down the toilet before the cops make it inside their home. If cops have evidence to believe people are actively destroying evidence in the home, they do not have to wait in order to obtain a search warrant to get inside the home. In the Supreme Court case of Kentucky versus King, there was a confidential informant that was involved in a controlled buy when all of a sudden the suspect took off on the run. Cops then started running after him and they thought for sure that he ran into an apartment. In fact, cops claimed for sure that they smelled the odor of burnt marijuana coming from inside the apartment, and then they claimed they heard the noise of evidence being destroyed. The problem? The guy they just knew had to be inside the apartment was not there. However, the Supreme Court ruled that this was a legal search because they were able to establish under good faith that this was an exigent circumstance based upon a belief that evidence was being destroyed. Here, the cops observed a felony drug deal take place in public. The suspect then fled, and then in good faith, they believed the suspect entered into an apartment. The Supreme Court really relied upon the police officer's report that said that they not only smelled marijuana, but that they also heard the sound of evidence actively being destroyed. So in that situation, it created the exigent circumstances that allowed the cops to break down the door without a warrant. Here's what is key though. In order for a police officer to break down your door without a warrant and invade your privacy, the cops are going to have to prove that the destruction of the evidence was imminent. Cops must prove that there was no way that they had time in order to go get a signed warrant and come back and execute the search. It's a totally different situation if a cop happens to be walking in a neighborhood and he sees what looks like a loaded greenhouse attached to someone's primary residence. Because the greenhouse is attached to the actual home, that would be considered curtilage. And the cop can't just walk up and barge into a greenhouse without a warrant. Because think about it, in that situation, he might think there's something illegal inside that greenhouse, but he has ample time to go back, get a judge to sign a warrant, and turn around and come back and execute that warrant. In fact, if the cop just walked into the greenhouse and grabbed a bunch of the marijuana plants and seized them as evidence, that would be illegal. Why? Because he would not be able to prove that there was any imminent exigent circumstance. Unless the cop was able to establish that the evidence was about to imminently be destroyed, he must get a warrant. Finally, what happens if a cop does beat down your door and come into your home without a warrant under exigent circumstances? If they find any evidence, can they use it against you? Cops cannot just search anywhere they want within the home, but if they come into your home under exigent circumstances, they can seize anything in plain view and they can use it against you. In fact, if they do find something in plain view, they may actually use what they find to go get a search warrant and dig even deeper to see if they can find any more evidence to charge you with a crime. Now, what if cops don't have exigent circumstances, but they show up at your front door knocking? Check out this next video where I break down 5 tips when cops come knocking. See you over there.